I wanted to go through several things in somewhat of a more high level and these things are usually issues that come up in the medtech space for various clients. And so we're going to talk about patentability versus freedom to operate. I think it's always worthwhile just kind of refreshing yourself about the distinctions between the two, why they're important. We'll spend some time talking about international and outside U.S. patents, some considerations of why you would file them anyway, and some cost, just to give you an idea of what that costs. We'll spend some time going through patents in the FDA, and this is a little bit a modification of a presentation that I gave at our conference in 2023. We'll talk about trademarks, and if we have enough time, we'll go through just how you overlay IP over a product, and it should be familiar to some. But let's go on. Patentability versus freedom to operate. So just to review, patents, and this is an important concept, I think, to help as you navigate any patent issues that you run into. But patents are exclusionary rights. They give you the right to exclude others from entering a certain space within the market. And that space is defined by the claims of the patent. Okay. We trade these claims and this right for disclosing what the invention is. And damages are recoverable for infringement of valid and enforceable claims. And we'll talk a little bit about validity. The claims, that's why you hire patent attorneys. It's what I spend most of my time reading and writing and evaluating and trying to get around or destroying. But this is the most important part of a patent document. Certainly the specification is, but the claims are really where it's at. It's where patentability is judged, and it's where freedom to operate is assessed. And again, you have these concepts of valid claims being novel and non-obvious. These are some of the basic requirements of getting a patent. And then this concept called inequitable conduct that we may touch on in a little bit before the U.S. Patent Office. You can't be fraudulent, basically. Patentability versus freedom to operate. On one hand, patentability is really focused on what about your invention is unique in order to obtain a patent for that invention. It's about building your portfolio. And the precise question is what we're going to what are you going to claim, and is it novel and non-obvious over the prior art? And this prior art are typically publications, mainly patent publications, but it's not limited to patents. It could be what we call in my business non-patent literature, journal articles and such. And a patentability search is something that we do in advance of preparing a patent application to get some indication of patentability. It's not a guarantee, but it does give you some sense of what the prior art is. It helps you draft your claims. I think it helps streamline the entire process as you go forward with it. We contrast that with freedom to operate. Freedom to operate is all about your commercial product. And the question is, if you sell this product, will this product infringe, or another word to put it is practice each and every limitation that's in a claim? So it's really a commercially focused question, not necessarily, it's technology dependent, but the patentability is looking at disclosures of prior art to get to the question, whereas freedom to operate is all about your commercial product. So we can go to the next slide and see what I have here. This just gives you a flow chart of the phases of a freedom to operate. Usually I like to break it up at least into two phases. I have three here, but phase one is, here's the universe of patents that are relevant. You know, what of all the things that we have found, what are the 10 or 15 that we really probably need to take a closer look at? Phase two is digging down into those patents a little bit further and saying, does this product practice each and every limit of the claim of all the patents that we have found in phase one? And you can follow the diagram here, but if you do infringe the claims of a patent, that's not the end of the story. We can test validity, because you only have freedom to operate can be non-infringement, but it also can be the patent's invalid for some reason. So phase three is usually something we do after we've determined whether or not we infringe or not. So basic overview of what a freedom to operate study is. We can go to the next slide. And timing. This is probably one of the most common questions I have about freedom to operate, about just patents in general is when should you do this? And I think in large part, it depends on what your purpose is and what you're doing. I have clients that are investors that sometimes are just looking at the broad concept of a company that they're potentially going to start. And they may not have all the products in mind, but it could be, I want to do a closure device, and assess that freedom to operate. And we proceed on that basis. If you've got a product and you're working towards a 510K or some regulatory, approval, then ideally an FTO is done as close to a design freeze as you can get, before you start to really outlay significant sums of money is what I would do. But not always do they need to happen with the patentability search, because when you have this initial concept that you want to protect. Go ahead. Yep.
Hey, come on in.
Oh, that's my friend Rick. All right.
Yeah. I lost my train of thought there. So patentability may happen earlier in the process. Your freedom to operate should be closer to when you're going to spend money or you have more details on your product, because again, we're looking at the product relative to the claims, and the more information we have about the product, the more I think you can rest in the assessments from the freedom to operate. The further you are removed from it, the more abstract the concept, there's going to be a lot of limits to what that study can give you. Okay. Let's see. With no questions about freedom to operate or patentability, we'll go right into international patents. So patents.
You have a question.
Sure.
And it's because I do packaging, and I always try and come up with a novel or unique way of doing a packaging for particular products, medical devices.
Yep.
And they never want to try and even patent them to make sure other people don't use them. Why is that?
It's hard to say. One reason might be it's not necessarily the biggest economic driver in the overall system. And especially if you're starting out or a smaller company, you may not have the budget to extend it to packaging. I like the idea of protecting packaging, especially if it's new or unique and there's something that might be transferable from one product to another product in sort of a packaging, because it's still some way to help control and protect the product or the offering along the value chain. And I've worked in the consumer products industry in the past, and we spent a lot of time developing patents for packaging, bottle shapes.
Yeah, I worked in foods and detergents for a while, and we patented a lot there, but medical devices doesn't want to do it. Right.
I've done a few, but it's not, I think more it's I don't necessarily think it's necessarily ignorance about it, but, I think it depends on, on the packaging. We've done some, but not, it's not a priority, for one reason or another.
Eddie?
Yes. Well, my experience is sometimes it's either better to keep something as know-how if it's not, sort of easily reverse engineered. But the other issue is just that the time and effort it might take to try to pursue those infringements if your main business is moving in a different direction. Yeah. Those are the two things I think.
Right. All right. We were just getting started on international patents, and patents, as you may know, patents cover really the geographic area and from the country or the region in which they're issued or granted. So in most cases, a U.S. patent is only going to cover the infringing acts within the United States and probably some territories of the United States government. There's some exceptions to that. So importing products into the U.S. is an act of infringement. So if somebody's manufacturing something in China and imports it into the U.S., the act of putting it basically on U.S. soil is an act of infringement, whether you sold it or done anything else. There's two primary ways that you obtain outside U.S. patents. The most common, I think, probably, this is more my gut feeling, I don't have any data to back this up, is to file an international application, or sometimes referred to as a PCT application. That's a placeholder. At the relevant time, you file the PCT application, and it gives you 18 more months to say, you know what, I'm not ready to make a decision about Europe or China or Mexico or Australia. I'm going to wait 18 months. And the PCT gives you the ability to do that. And in the meantime, you get this non-binding search report that is some assessment of the patentability of your invention. The other way is at the appropriate time, which is 1 year from your earliest filing date, is to just file. You know what? I don't need a PCT. I know I want a European patent. I'm going to file direct in Europe right then. So one of two ways. This key considerations is a good next step. This is sort of the basis that I would use or have used to guide clients in deciding whether you're going to file outside of the U.S. or not, or file a PCT application or not. And my focus has always been and will be, our first goal should be to protect whatever revenue that you're going to generate. And if you don't have a market outside of the U.S., then of course that's sort of a strike against filing. But there may be other reasons. Where's the primary manufacturing infrastructure for you or your competitors? Where would this thing actually be made, or where could competitors make it? That may be a reasonable choice for filing or considering to file outside. Locations of key competitors. Enforcement, this is a question I get often, is it worth getting a patent in China or a patent in Mexico or other places? And that's not an easy question to answer. 10 or 15 years ago, I would say people are filing in China because everybody was filing in China. It wasn't really the sort of coherent and dogmatic support about the enforcement system in China. But over the years, there has been foreign defendants that have won patent judgments in China. Not a lot, but it's different than it used to be. So there's more filings in China than there have been at any other time. And that's one, maybe one reason is because so much is manufactured, over there. Cost, if we can go on to the next slide, I think I've got some just estimates. So an international application, your filing cost is going to range between $2,500 and $4,000. As if you recall, I mentioned that you get this search when you do a PCT or an international application. And when you file the international application, you get to pick amongst 3 or 4 different patent offices to do the search. You can pick the United States. I usually pick the European Patent Office, Korea, Israel, and they all have different costs and different, benefits. I like Europe because that search is used throughout European prosecution, and it really does give you a sense of what Europe will do. So there's some variance in filing cost. There's no requirement to do anything else other than file your international PCT application, but you can evaluate the search report and file arguments if you choose, or change claims. And it could result in some limited prosecution costs there. And then once you've gone through that 18-month period, you then enter the national phase and you don't have any ongoing cost there. So we'll go back just a little bit. Direct applications. So this is more or less what you would file on a country by country basis, or what it would cost on a country by country basis if you're filing direct. But it's also a good estimate of what you would incur after your international application expires, and then you enter into Europe or China or Canada or what have you. So usually, I won't say usually, but a lot of times a conversation will go, I really want to protect the invention in 10 or 12 different countries. And then we start going through the cost and yearly annuities. And that often gets reduced down to, 3 or 5 if outside US patents are important. I have clients that are thinking about the markets where their strategic investor is filing patents, and will sort of match that. So that's one. If you have a strategic on board, or you're targeting a strategic filing outside of the US, it's helpful. It's attractive. I don't think it hurts in terms of, their consideration of you. But there is this, at least, demand, by clients to seek coverage where they think some of the larger players are going to be filing. But this gives you some sense of cost. Any questions on foreign patents before we go forward? Nope. Quiet. So this is probably the bigger section, of the talk, and this will look, familiar. And as you know, there's certain regulatory strategies that you can pick, or that is dictated by your product, and then our patent strategy. You're developing patents and you're trying to get them through the patent office. And there's certain areas where there is some overlap, and it's considering what you're doing, or at least try to understand that a little better. And the areas in the overlap here, the safe harbor, we're going to talk about that. It's an exception or defense to patent infringement. Patent marking, how do you go about obtaining patents in view of what you're doing in the FDA? Coverage is related to that. Third-party patent infringement, term extension. These are all areas where there's some interplay between what your activities you're doing with the FDA and what you're doing at the patent office that need to be coordinated. So next slide. Okay, safe harbor. Normally, if you make, use, or sell or import into the U.S. an invention that's claimed, that's an act of infringement. This act, meaning the making, the using, the selling. This section of the patent statute was enacted as a way to give basically a safe harbor, essentially originally for pharmaceutical companies to conduct research on products while the patents were still valid and enforceable. Instead of having to wait until the patents expire and then conduct research. The premise being that any kind of research that you do on a patented composition or a molecule or whatever is still use and would be patent infringement. So there's an exception that says it's not an act of infringement if you're doing all these acts, making, using, and selling, or importing in the U.S. solely for uses reasonably related to the development and submission of information under federal law, which regulates the manufacture and use of similar drugs or biological products. Now, it doesn't say medical devices there, but cases have subsequently applied this to medical devices. Eli Lilly, you can see there at 90. Some examples here: the use of a patented method in research submitted to the FDA to obtain a labeling change. That was deemed safe harbor, activity. But routine quality control testing was not protected, activities. That under the premise that, well, quality testing isn't necessarily attendant to gaining approval for manufacture of a medical device or pharmaceutical. So just some examples. And then the next slide, we'll talk about a recent case within the medical device area, Edwards v. Merrill. And what happened here, Merrill, some representative from Merrill, they're based in India, came to the United States and attended a conference. He brought with him perhaps luggage, 2 transcatheter heart valves. The facts indicate that the valves were never taken out or demonstrated at this conference. And Merrill's position was, we imported these 2 devices, and we attended this conference because we needed to find PIs to help with our clinical research in efforts to gain approval in the U.S. They had approval in Europe, they had approval in India, but not in the United States. They attended the TCTC, and soon thereafter, Edwards filed suit alleging patent infringement. Merrill said, no, this is a protected use under the safe harbor. I think we'll go to the next slide. I wonder if back up. Sorry, I thought there was something there. The appellate court essentially agreed with Merrill and said, bringing over devices to attend a conference, to look for or identify investigators for clinical research purposes that then would be used to support an application for marketing before the FDA, clearly a safe harbor. It falls, firmly within there. This case was decided in March of 2025. There were some dissents filed, and I don't know if we've heard yet the end of this, but this just gives you another example of what can be a safe harbor when you're doing your research and development activities. All right. Damages. we've talked about damages a bit, and in the patent marking is an important way to start the damages calculation. Now, normally you have to either to give notice of infringement for purposes of calculating damages, you either have to send a cease and desist letter, you have to file a suit, or you can comply with the patent marking statute. Historically, patent marking required that literally the patent number had to go on the device. Like if it were, somewhere on the handle of your catheter or somewhere, literally printed on it. Can we go to the next slide? So Mark,
I wonder if you can, I made you co-host, so I wonder if you can now see next slide.
nope.
Okay, please continue.
Okay. Or, so instead of marking directly on the products, and if you've got 10 or 15 patents, that's going to be hard if you have the smaller products to do. You can do virtual marking where you put your URL on the product, www.gregsmedicaldevice.com, and on that website, you add your patent numbers. What this does is start notice for damages purposes at the point that you comply with the act. So it's a way to increase your damages base. This is a question that comes up in every due diligence investigation I've been involved with in the medtech space. Especially if it's a strategic, they always ask, what's your patent marking strategy? If we don't have one, it's usually one of the conditions that they want to see, squared away. And it's relatively easy. We're going through a label change now with one of my clients to help, comply with this. It doesn't, the URL doesn't take up a lot of real estate, on the label. Now I can sit here as a patent attorney and say label change should be easy. I recognize it's not, but it seems to me a pretty simple thing to do to increase the value of your portfolio relative to your products.
I am surprised to hear you say that legal is involved in a label change. I would think that's, like you said, pretty straightforward.
I mean, I'm not necessarily working through the label change. It's more, we're recommending you do this and change your label so that you can comply with the patent marking statute for purposes of increasing your damages base.
I see.
Yeah.
Okay, but it's atypical. It's not something
Right.
that right. Okay.
And I think this is part of the point. There's certain areas in a number of documents that are submitted to the FDA that probably should have some, feedback from patent counsel, at least at some level.
So
it's easier to create this label earlier than try to do a label change later, unless there's some other need to do it.
Is reviewing labels a standard thing that you would do for a client before a patent is filed?
Not necessarily. Well, usually before the regulatory documents are filed. Okay. So whenever the package is submitted that will define what the label is, I would have patent counsel review that to make sure that at least you have some patent marking URL on there.
Don, I saw you come off mute. Did you have a question?
Yeah, just Greg, can you use a QR code to point to the URL?
I think so.
Okay, thank
Dan,
you.
do you have a point of view on that?
No, I was just saying that labels are the major reason product gets recalled. So having the patent lawyer look at it before you actually put it on the market and submit it to the FDA is
Prudent,
really
but Don was
a good
asking,
idea.
can you use a QR code in lieu
a QR
of a
code, you'd have to ask the FDA because it could be mixed up with a 2D code that's required on product. So I'm not clear how far you'd have to separate it out to make sure there wouldn't be an issue.
Michelle, do you have a point of view on that?
No, I just generally agree that I don't think people are strategic enough about what they're putting in their labels and reviewing it. And like people are pretty lax about turning in draft versions of their IFU. And then they add or change things later, and they're just trying to turn into the FDA like real bare basics. But then they add stuff that either changes their IP or their patent or their claims, or
Right.
they make new things that should have been in their 510K in the first place.
Don, do you feel clear, or are you still not
that's-
sure
That's
about?
fine. I understand. Thank you.
You bet.
Ready.
We ready for the next slide, Greg?
We are. So we're just following on what Michelle said. One of the things that I'd like to have my clients do, and you all who are developing products, is there needs to be some correlation, good correlation between what you're submitting at the patent office and what you're submitting, to the FDA. If your patent doesn't cover the indications and the instructions for use, that's not the greatest thing. It lessens the value of the IP relative to your product, and it's just a negative that can be addressed with some proactive involvement of counsel while you're submitting the FDA. Now, I don't, there's some situations where we may adjust some language and there's some back and forth, but for the most part, I'm just trying to confirm that, all right, my patent claims and my disclosure is consistent with what we're putting in the 510K materials and the PMA materials, or whatever you're putting in the materials that describe, the product. That does a couple of things. One, it helps ensure this correlation between scope of the FDA documents and scope of the patents. But it also gives the Patent Council a sense of what positions you may be taking with the FDA, and those positions being consistent with what positions we may take relative to the literature at the patent office. So understanding what the predicate devices are. Here, this is one way to kind of adjust your patent strategy as your regulatory strategy shifts, over time. You can file a continuation, and then if you have some new uses or new indications that you're trying to add on with additional, submissions, you can file continuations in part that will allow you to keep earlier priority dates, but still give you the coverage that you want. Again, you can only do this if you're talking to your patent counsel, or at least let them know, look, we're thinking about a significant label change, or we want to broaden the scope of the claims that we're trying to make. Do we have coverage for it in our current portfolio? And then starting that discussion to make sure, that you do. There's some limits around that because you are kind of bound in time from what's been published, before. But again, having that conversation is probably the more important thing than the actual necessarily the outcome of it, because you may be fine.
Joe, could you go back a second?
Yep. Back further?
To the previous slide.
This one?
No. Yes, that one.
Okay.
So Greg, what do you see for startups being cheap and not iterating with their IP attorney at these different stages? Because on the regulatory side, they don't call me until it's already kind of too late in the process. Right. Or if they call me at the start, they don't call me incrementally to tell me the progress or the changes they made. What is your experience with that?
Yeah, it could be. Some of it depends on the culture of the client, and their size. I have one client's a good example. They know that when there's iterations or designs that there's potential IP. I don't look at everything. They have some internal dialogue about ideas or concepts that have some merit that may warrant them creating some prototypes, and are they found some things that kind of work in the lab. And then at certain time intervals, maybe it's once a quarter, we sit down and kind of go through just what are some concepts that you're working on to kind of pick up that, that iteration. And that quarterly review more or less will happen until they get to a design freeze. And, at that point, if the product's not changing anymore, then we're just trying to maintain the portfolio. It's not practical to iterate with your patent attorney every day. I don't think it's necessarily helpful. But there are certain time periods where I think it makes sense to reach out.
Mm-hmm.
One quarterly may be enough. Anytime you're considering any change in your regulatory documents, mm-hmm. compared to a previous filing, I think is a great time to reach out to patent counsel.
To your
That's-
second point there about the special controls for a de novo, I think also companies underestimate the power of being able to set the standard for subsequent 510Ks by defining the special controls.
Right.
And
Right.
you can tell when the FDA issues a new regulation out of a de novo, who understood it and who didn't, because I've seen some regulations that were 2 sentences, and I've seen some that were almost 2 pages worth of specifications that the product had to meet.
Right. The special controls, and I mean, that's a barrier to entry, and a useful one. And I think, smart use of that, as you described, is really important. I mean, that's, I've had a couple of clients kind of weigh de novo, PMA, and they've gone with the de novo route. I'm not sure what the timing is. I don't know if they're taking a longer time now to do the de novo than they had a few years ago, or how that relates to the PMAs, at least right now.
I think the average, the last time I looked, was 400 days for a de novo and 800 for a PMA.
Okay, yeah, so it's still faster,
Mhm.
and probably less expensive. So whenever, just again having the conversation, certainly understanding that there are special controls out there could adjust a strategy we have in clients that I've worked with, and then just making sure you're adapting your patent strategy as you are adapting your regulatory strategy, I think, is the more important point. This one, so inconsistent statements made to the FDA that are contrary to a position that we take at the U.S. Patent Office pretty much ruins the patents. Okay, you can't say to the FDA that this prior art is terrible and then say it's great at the patent office and not expect some negative, consequence. So this example, and I talked about this in I think in one of the 10X. The person that was in charge of regulatory strategy and the person that was in charge of patent strategy was the same person, and it wasn't really sort of team based. And so he was directing, information and statements to these 2 different agencies that were inconsistent, and that came back in a later suit and essentially invalidated the patent because of this use of inconsistent statements. So being consistent, understanding how you're different and from what the literature says about the predicate device and how you're similar, is an important consideration. Okay, and this is just a summary of different pathways, strategies that are both offensive, and defensive tips, to do. For example, for the 510K, ensure your product and method of use is consistent with the IFU, employ your patent marking, file your continuations. For the de novo, you're doing a little bit more, and maybe you're having some additional protection focused on these special controls if you can work out the timing, in the right way. Patent marking, PMA, again, think about patent term extension. That's different. You get time back. You can add to your patent term for regulatory delays if you have a PMA, filing. So the pharmaceutical companies do this all the time. Medical device companies do, but patent term expiration is it's something that I talk about with clients, at least monthly at various stages. And we know exactly when these patents are going to expire and what we're trying to do to counter, or at least to account for that reality. So patent term extension is an important thing from a defense. Go ahead.
Yeah, I want to just ask on behalf of Don Collins. He's going to present on the 25th, and I spent some time with him. I'm hoping that you, Greg, and Jan and Michelle, at a minimum, can join us on the 25th, because I think he needs to hear what you have to say.
Okay.
Thank you, Joe.
Mm-hmm.
So on the defensive side, and this is thinking about your competitors' products, let's look at the language in the 510K summary and the IFUs. Evaluate all, if somebody has a predicate device, it's not difficult to look at that predicate device and see what patents are being covered by it. It's sort of logical to assume if you're using this product as a predicate device, you might be infringing that predicate device IP. Might be, but it's part of the FTO analysis. Looking at, for the de novo, again, consider if your product can function as intended with special controls and still avoid third-party IP. So that's with the FDA and the patents. We'll spend a little bit about trademarks and branding. And this is a bit more just sort of some basic information. Trademarks, they identify goods or services. I give the example of Tide. I grew up with Tide. You know I have an emotional response when I smell Tide. It reminds me of my childhood. It identifies a source of good or services. It could be a word, logo, a phrase, and a combination of those. The big issue is that brands, trademarks shouldn't be confusingly similar with something that existed already.
I'm intrigued. I've never really thought about the smell of Tide. So you could have a patent infringement if your scent smells too much like the other scent.
There is
I can
a
see the
base to
perfume.
have a trademark right to a scent. I think the Owens Corning pink fiberglass, that color is trademarked, and sound, the NBC.
Bum,
Chime.
bum, bum.
Right.
Yeah, when
That's
I worked
also-
for Lever Brothers, they did patent their perfumes.
Perfumes, I'm not surprised, but yeah, I guess anything that's has a smell introduced.
Yeah.
I'm under the impression that you can slap a TM on the end of anything and it gives you some protection as the first person to ever slap a TM on the end of a sentence. Is that true?
Yeah. I wouldn't, not necessarily, everything. If you slap a TM on something that's just descriptive of the products and services.
Right,
you've just
I
added-
get it.
Yeah.
But
you've
any
added
saying
a
you come up with.
Right. But if it's, if it's non-descriptive, arbitrary, fanciful, suggestive, these are words that we use to describe certain types of trademarks that have stronger rights than others. So you're going to have weak trademark rights the more descriptive it is. You can attempt to put the TM on it. It may not hold up under scrutiny at a later time. But the TM versus the artist circle, TM, it really signifies a common law right. And your trademarks arise, as soon as you use them in commerce. So you can apply the TM there. The registration, of course, requires a filing and some back and forth between the trademark office until it's formally put on the principal register, we would say. A couple of things to do from a trademark perspective is consider a clearance search when you're coming up with your trademark. And a clearance search does two things. It helps you understand if your word, phrase, logo is going to step on somebody else's territory, just to kind of know that ahead of time. But it also gives you a sense of how registerable that trademark, could be. There's different types of clearance searches, but if you were to do a comprehensive search that looks through, of course, the USPTO database and other commercial databases that the trademark office looks through, you're in the $1,500 to $2,000 range to do this sort of comprehensive clearance search, and then you can file your applications at a later time. But again, to me, the most valuable part of the clearance search is understanding that you can avoid infringement by knowing what's out there ahead of time, and avoiding having to rebrand at a later time when somebody sees you using their mark and complains about it.
I'm aggressively forwarding the slides because I definitely want us to get to slide 33.
Yeah, just
Right.
our brands, our trademarks. Can you have the same trademark within two different industries?
You can, and from a registration standpoint, we associate a trademark with a particular class of goods or services. So it's not it's possible to say I have a trademark for food and then a separate one that is business consulting. Maybe those two marks might be the same because the patent office and others have determined a reasonable consumer wouldn't be confused by looking at a trademark for food and one for business consulting. If it was business consulting for food, it'd be a little bit closer of a call. All right. But normally you're looking at a class, there's classes for apparel or pharmaceuticals or what have you. And then you have a description of your goods and services. And that this idea of confusingly similar is going to be somewhat predicated on how the word sounds, how it reads, and that class and those channels of trade. So it's possible, but
Thank you.
yeah.
As
All
part
right.
of your service, if you're working with someone on that, are they responsible for going in and re-registering when there's no notifications ever sent from the offices?
Yeah, no, so when we work with clients on trademarks, we put everything in our docketing system and then have built-in reminders. Even for the later, over time, you have to submit specimens of use at 5, I think, and 9 years, and we keep track of those. Most firms will keep track of that, so that you don't have to keep track of those notices.
Yeah, it's just the pain.
Yeah. Okay. Next slide. You wanted to get to,
Yeah, let me do that. Well, we can stop here.
yeah. So I guess we got a few minutes, but just a summary: trademarks protect sources, goods or services; copyrights, creative works, what you write, what you draw, code, things of that sort. Trade secrets, it's valuable because it's secret and nobody knows about it. And patents are products and processes. And you have some of the term listed here. But the next slide, we've looked through this before, but I'll try to read this quickly. New company develops a health monitor. It's got a sensor. It has improved, data needs. It has this nice communication system. It does the work of 3 different things. Marketing calls it new device. You use new coding software to develop it. And it's used to operate the sensor module. And plus you use open source software. And on top of that, we use this compilation of data that's been accumulated over the last, 20 years. So if you advance new and new device, these are examples of your trademarks. These are potential trademarks. If we keep going, copyrights, could be the shape, the code, the software. The open source software implicates copyrights. They'll have certain uses or attribution requirements. Then we'll go to the next one. One more. Patents. You could have the patent to the health monitor, the sensor module, the data rates, the shape could be a design patent, the software. And then I think the last we'll have trade secrets. One more. There you go. Trade secrets could be the software, the physiological data, the coding scheme. So this is just an example of
I think
how
you're just trying to overbill us.
well, no, but this is
Right.
what
Well, I'm
we
gonna throw my bill in here and say, how does this affect what you want to put in your 510K summary that's public?
right. Well, if you have not trade secrets, not anything that you want to protect unless there's been, a patent filing. And there's a number of things here that you don't, for copyrights, they arise at creation. You don't have to register them. If you want to sue somebody for using your copyrighted work, then you have to register them. But copyrights exist as soon as they're created. And the bigger issue there is, do you actually own it, or does your independent contractor own it if they did that for you? That's the bigger question. Trademarks, of course, you've got common law and the registration. I've had clients that have used common laws until they were acquired by a strategic, and then they started filing trademarks after that. So it's not unheard of. And then, patents are about trying to figure out what's the most important part that you really want to, extract value for. Is what you're going to put in the box that you're going to ship to your customer or the hospital, the health monitor, or is it the sensor module that you're sending to somebody else that's going to compile it and put it in the health monitor or the health device? So understanding where you are in the value chain helps reduce some of that outlay. Jeff.
Patricia asks, what's the advantage or disadvantage of a startup choosing a provisional patent rather than a standard one?
The advantage of the provisional, sometimes it should be lower cost. It gives you 1 year to do further development, to get investors. And then when you convert that from the provisional to the standard, you can update it with whatever developments that have come through in the past year. The disadvantage is it's going to be over time a more outlay because you're filing a provisional and then you're updating it, and it delays the time from which you will get a granted patent because you're adding a year onto the whole process, basically.
Andre?
Yeah, thanks, Greg. I think that was a very good presentation overall. We've developed part of our engineering service, we've developed over 50 patents for our customers, and they're all typically small and startups and so forth. So we make active use of provisionals to protect them, at least during the development phases when we're developing something new. But one thing you didn't talk about, and that's something that's actually hurting the industry right now, yours and mine, is the whole problem with the PTAB and how it's going against small developers and inventors. So I don't know if you had any comment on the PTAB, because it certainly is putting a damper on people's interest in patents.
No, there's a number of things that our government has been doing that I think undermine patents. PTAB is one. The difficulty of getting a preliminary injunction. 25 years ago, if you could reasonably prove infringement, courts would issue an automatic injunction. And that's what terrified operating companies, because they've invested money, presumably, on their own thing, and didn't want to, have to deal with this seizing of products while trial goes on.
Is this relevant?
There were just some backup slides. Yeah, not relevant.
Okay.
Right here. So that injunctions, I think, limiting the patentability of certain inventions in the diagnostic space and software is another mistake. There's the statistics for the PTAB, as you know, are concerning, and even in the last several years, we found out that, the director has in the past adjusted the panels of the administrative judges to direct the outcome. Like, that's a terrible place to be.
Exactly.
If we're picking administrative law judges based on who's a party to, the petitions, that never happened until this time period that we're in, right now. To me, that's it's just shocking that our patent office would engage in that, but not surprising either.
When did that actually start? That's been going on for about 10 or 12 years. I'm trying to remember.
I didn't get that, or I didn't. You could speak closer to your mic.
Yeah, I've got some transmission issues while some repairs are going on in the house. So can you hear me now?
Yes.
Okay, good. How long has that been going on? Has that been going on 20 years, or is it
the PTAB? Yeah.
Yeah.
The PTAB started in I think the act was passed in 2011. It probably didn't start until 2013. So we're 10 years in.
Yeah, but within 2 years, Greg, it went all against the small inventors, with the larger companies really taking over and getting all of these patents invalidated, which is really killing innovation. It's going to hurt the country, and it's certainly not what our founding fathers felt when they put it right into our Constitution to protect somebody that creates something. So,
Andre, did you attend Randy's conference?
No, I was not there.
Okay, I wondered how it went. I haven't heard back from him.
Yep.
I think Randy's organization is great. It's probably the one that really does focus on inventors and is trying to do what they can to affect the sort of legislative outcome. And there's some promising bills that are in. Who knows? Nothing is going to happen, before January.
Yeah, but for the benefit of all of us in medtech developing new innovations, something's got to change. Otherwise, it's going to hurt us overall.
Greg, thank you for being our family IP lawyer. We appreciate a belated happy birthday to you. And next week, Daniel Shepard, we haven't seen him in a while, will be back. He and his company just completed some M&A in the space, and he's going to take us through it. I think that'll be an interesting talk. So,
great.
On behalf of Joe Hage and Joe Hage Enterprises, this has been Joe Hage. Thank you all, and I'll see you next week.
Bye, everybody.
Thanks a lot.